Welcome to Expert Views on ADR EVA, a podcast about simplifying the traditional African method of settling disputes or appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of Dispute Resolution Mediation Committee. I am delighted to welcome Professor Kevin Scudder to the EVA show. He is a collaborative attorney, mediator, writer, trainer, and founder of the Seattle Collaborativelaw Center, PLLC, based in Seattle, in Washington. He is a board member of the International Academy of Collaborative Professionals and past president of Washington State statewide collaborative organization, the Collaborative Professionals of Washington. Kevin wears many hats, so I've left the links to his profile below. Welcome to the show, Kevin. Mr. Shane. Thank you so very much. I'm so honored that you agreed to, come on the show and speak about collaborative law.
Yeah, thank you for having me. And I noticed on your slide that you don't have collaborative law as one of the dispute resolution processes.
Don't worry, after the show, I'm going to add it. Thanks. Thank you. So without further ado, the first question is, what is collaborative law and its impact so far in the United States, precisely in Washington?
So in collaborative law is a dispute resolution process where each party is represented by an attorney, and the parties sign a contract called a participation contract. And the keys to this contract are, we as attorneys, around the world, we have ethical obligations and rules of professional conduct that govern our practice.
Yeah.
And, they say what we can and cannot do as lawyers. In the collaborative process, we're modifying those rules of professional conduct to break down the barriers that in a traditional way of practicing law, create barriers to a resolution of a conflict.
Yeah.
So the participation contract, commits everyone to good faith negotiation, full transparency, full exchange of information.
Mm-hmm.
We waive the rules of discovery, so there's no interrogatories, no depositions, no subpoenas. And the other key to the participation agreement is that the attorneys are disqualified from working with either party outside of the collaborative process. So in the collaborative process, everyone is saying we are not going to go to court to have a third party make any decision whatsoever regarding our conflict. We're going to trust the process and get the information we need to make decisions. So that's the starting point for a collaborative process. Okay.
Yeah.
I do a lot of work in the marital arena, so in divorces. So, I like to talk about, there's three areas when couples uncouple. One of them is the emotional aspect of, a marriage not working out the way you thought it would. There is a financial uncoupling. How do you untangle our finances? Because we've made joint decisions. And third is the legal aspect, because here in the state of Washington, divorce is, a legal aspect. So we bring in experts for the couple in dispute to help with those other areas of uncoupling. So we bring in a coach, a mental health professional to help with the emotional uncoupling. And if there are children involved, the coach is really taking the lead on putting together the parenting plan with the parents. We bring a neutral financial person in because in a traditional litigation setting, oftentimes the couple will each hire their own financial person and put them into their war chest and have that financial person, take positions as to what is good outcomes. But in the collaborative setting, we use one neutral financial professional to gather all the financial records. And then each person has their own attorney, to help them understand the law, understand the process. So here in the state of Washington, collaborative practice really has taken off. Since, I took my initial collaborative training in 2008, but the original collaborative training happened in around 2002. So over 20 years ago. And so I stopped litigating in 2010, so all of my work is mediation, collaboration, client-focused, out-of-court dispute resolution work.
Right, and thank you so very much. So I have two questions, like about the cost aspect and time as well.
So let's start with time, okay? Because I've done over 200 collaborative cases, and I collect data. I know you're a PhD, you did your PhD studies. Data is great because it helps parties make informed decisions as to which dispute resolution process to choose. So a typical collaborative case on average is going to last 4 to 8 months. And the number of meetings, we do 2-hour meetings on a periodic basis. So it takes about that 4 to 8 months of time. It's about 4 to 6 meetings, team meetings, to work a case from the start to resolution. In terms of cost, a lot of it is dependent on the ability of the clients to do their homework. Okay. If the lawyer is, if I, as one of the attorneys in the process, have to always remind my client, hey, look, you got to get the financial stuff in. Hey, you have to work with the coach. Hey, then the process gets more expensive. So in terms of, how can I tell you about cost? Because, a dollar amount here in Seattle, Washington is going to be different than a dollar amount in London or Nigeria or Cape Town.
Okay, so what I'm trying to get is are there any differences or similarities like between mediation and collaborative law? Because you find that in mediation is cheaper, to settle via mediation. So that's what I'm trying to get from you.
I would guess that mediation is going to be less expensive.
Okay.
Okay. Because there are less professionals involved. The thing is that one of the things about collaborative practice, and I think any lawyer has an obligation to assess their client or assess the parties for the suitability of the process, because mediation doesn't work for everyone. Oftentimes as mediators in our room, there's an imbalance of power, or there's an unwillingness to share information. And people are making decisions simply to get done and not looking for a quality result or a durable result, right? So let's talk about durable resolutions, okay? Because in mediation, oftentimes people give up. They say, look, I'm just going to sign off because I'm done with you, The other thing about mediation is, are the parties working with attorneys or not working with attorneys, right? Because if I, as a mediator, am working with parties who, here in the state of Washington, we always recommend they go get attorneys because we as mediators, as you know, can't give legal advice. So what happens is I will help craft a resolution with the parties, and then they go to the attorneys, and the attorneys blow up the agreement. and they say, oh, I could have done better for you. I can do better for you. Give me a few $1,000s and, I can get you a better result. And it creates conflict. So there's the direct correlation between attorneys creating conflict and increased fees to the party. So in the collaborative process, because of the disqualification provision, right, the attorneys are disqualified if there's not a resolution. The attorneys have no interest whatsoever in blowing up the agreement. So taking unreasonable positions or advocating for your client in a manner that pushes the other party away, that creates conflict, you're going to get a lot more durable agreements in the collaborative process than you will in the mediation process, especially in the family law setting, because we talk about couples, parents creating a legacy for the children, because you're always a family. You may be a 2-home family as opposed to a 1-home family, but you're always going to be a family. So the children are going to be happier, healthy humans if their parents are able to be in the same room with each other, for high school graduation, marriages, birth of children, etc.
Yeah. Oh, so, and thank you so very much. So the similarities I can say is the part of peace building.
It is. There is an element of it's like I showed you my button and my mug. My mantra every day is peacemaking. Let it begin with me. Okay, because I was trained to be a warrior in law school, and I realized that was not the best way to help make the world a better place, to spread to create less conflict in the world. So what I realized as an attorney here in Seattle, Washington, is it's not about me. It's about the clients. We all walk in the world with different ideas of fairness, right? I think we all want to be treated fairly and feel like a result is fair. And so it's not about my idea of fairness. It's about finding out from the clients, do they have a rights-based? Do they believe that whatever the law is, that's their idea of fair? Maybe their idea of fair is faith-based. That whatever God says, whatever the Great Spirit, Mother Earth says, that's what I think is fair. Another is needs-based. Some people think, that person needs more, or I need more. And that's what I would like to see happen. And the fourth one is equity. Equity is when I see it, I'll know what it is. So the courts don't operate that way, right? But we as collaborative practitioners or peacemakers can help the clients identify their own sense of fairness and help them create their own law. Okay, and if they're creating their own law as to how to divide assets or put together a parenting plan, they're more likely to be willing to, number one, stay out of court in the future because they're happy with the resolution. So they're going to have a reduction of fees because they're not in conflict, in the future, and it's just a more durable resolution.
Okay. So thank you, sir, so very much. So the similarities would be compromise, concession, cost effectiveness, and time factor as well, which is lesser than it is in the traditional litigation.
That was a very good summary, and I think the other concept that's really important is self-actualization and self-realization. For our clients, is let's let them shine in whatever dispute resolution process they choose, as opposed to impose an outside judgment on them.
Okay, thank you so very much. So like we have the transformative, mediation, facilitative. Is there any model with collaborative law that you can use?
So can you ask that question again?
You know, we have directive models of mediating. That's facilitative, directive, you know, where you have you assist, your job is just to assist the parties. That's a facilitative. And directive, you can as well give your own opinion and amongst others. Is there any model associated with collaborative law?
That's a wonderful question too, because I believe, and this is my personal belief, and I think, you know, Stu Webb, the founder of Collaborative Practice, I think David is this way, is we use a facilitative approach in the collaborative model. Okay, we facilitate dialogue, we you know, support, you know, non-judgments, you know, listening, active listening, you know, and helping the clients listen to each other. And so we stay facilitative, Chinwe, as long as we can.
Okay.
You know, we have an ethical obligation as lawyers, though, which doesn't go away in the collaborative dispute resolution process, of letting our clients know whether the resolution they reach is within the ballpark of what we think would happen for them in court. Okay, so that's more directive. And sometimes, you know, clients in the collaborative model will get to the place where they say, what would a court do? You know, what does the law say? But then what happens, Chinwe, which is different from, you know, litigative mediation model with lawyers, is that conversation happens in a team meeting. So if you are working with the husband, I'm working with the wife, and you and I say, hey, the clients want to hear what the law is on spousal maintenance, or what the law, or what a likely outcome is. I wouldn't talk to my client outside of a team meeting, you know, and you wouldn't talk to your client outside the team meeting, because if you tell your client outside a team meeting what a likely outcome is, you know, they get positioned. Okay. And if I tell so you tell your client this ABC is going to happen, and I tell my client XYZ is going to happen, they're going to be polar opposite and positioned. Okay, so the conversation about likely outcomes and results is all done at a team meeting. So we're there with both clients, and then we would say, hey, Chinwe, go ahead and, you know, what do you think is a likely outcome, or what's the law on property division and spousal support? Because I want my client to hear from you, and you want your client to hear from me. So what's interesting, though, is when we do that in the collaborative model, the attorneys are basically saying the same thing. You know, we can't tell you exactly what a court is going to do, because it depends on the implicit bias of the judge or the arbitrator who's making the decision for you. We don't know if they've had lunch or not had lunch. We don't know if they're tired or, you know, or awake and they've had their, or whether they, you know, have to go to the restroom, you know. So, you know, we give them the ballpark. So it's a great way to meet our ethical obligations to our clients, but also not creating conflict. You don't want to create a bonfire, because then you talked about costs earlier. Then fees go up.
All right. Well, thank you so very much. You mentioned Steve Webb. I was about asking about the history of is there any history to collaborative law?
Oh, there is. You know, and the interesting thing is, you know, people talking with each other, and coming to resolution. It goes back to the first people, the First Nation of people. You know, it's like when there used to be conflict, you know, groups of people would come together and, you know, and talk to each other, you know, and so law has separated that. They said, you know, first of all, we have to separate our clients. They're in conflict. they shouldn't talk to each other. Lawyers can't talk to the other party.
Yeah.
They have to go through the lawyers. So all of a sudden the lawyers become the mouthpiece, right?
Yeah.
So what happened in Minnesota, back in 1990, Stu Webb was an attorney who was just fed up with the legal system.
Mm.
And he came up with this idea of collaborative law. And he wrote a letter to the Supreme Court, one of his Supreme Court justice friends that he knew. And he said, hey, what would happen if the two lawyers and two parties, instead of fighting in the court and filing motions and doing depositions, all sat in the same room together? Okay, and just came and did a facilitated settlement negotiation. And so he was in Minnesota here in the United States, which is in northern middle of the country. And so he started that practice. Now, interestingly, at the same time, on the West Coast in San Francisco, there were two women, one by the name of Pauline Tesler, one by the name of Peggy Thompson, who said, you know what, we are going to start. They started doing it on their own. Yeah. But their twist was to add the mental health professional. Peggy Thompson was a mental health professional because, as I talked about earlier, the emotional uncoupling of the parties, their thought was if you could address the emotional uncoupling, it would reduce conflict. Okay, so they started using an interdisciplinary approach. So when Stu Webb met Pauline Tesler and Peggy Thompson, it was like, holy smokes, the world is our oyster, and the collaborative practice was born, basically, or I would say reborn, because they've been, this is the way, the First Nations would resolve conflict.
All right, thank you so very much. I think we have 9 more minutes to go. So what are the aims and objectives of the Seattle Collaborative Law Center? But before that, just a quick summary, what cases or matters can be settled via collaborative law?
So collaborative law here in the state of Washington can be applied to any disputes.
Oh, okay, good.
Okay, so we have a statute, the Uniform Collaborative Law Act, okay, that sets out, and it's RCW 7.77 if anyone wants to look up our Uniform Collaborative Law Act. It just sets the standard of how to address any conflict. So I use it in family law settings, but I also use it in probates, which is when someone passes away. Yeah. Okay, sometimes and oftentimes the heirs are very sad and distraught. And there are conflicts about things about the estate, who gets what thing. Yeah. So we use a collaborative law approach to meet with the family. We bring them all into one meeting, one room, okay, to help address the conflict. Okay. But it can be used in neighbor disputes, boundary line questions. It can be used in employer-employee relations. It can be used in business disputes. Yeah. Mark Sheridan in New York is a big civil collaborative law trainer and practitioner. Okay. And there is, as you said in your opening, I am a member of the International Academy of Collaborative Professionals and a board member, but I'm also a board member of the Civil Collaborative Organization, which is the Global Collaborative Law Council, GCLC. So it is used in both, family law matters and civil matters.
Okay, and thank you so very much. So, what are the aims and objectives of the Seattle Collaborative Law Center?
Okay, now this is just between you and me, right? Yeah, yeah. My aim, is to change the way law is practiced in my part of the world. I just, coming out of law school and doing 21, 22 years of litigation, I just felt it's not the way to handle conflict, so I spend a lot of time, interacting with litigators, interacting with, other dispute resolution professionals to model a way of practicing law that puts our clients first and empowers them to make decisions. So not all cases are collaborative, right? Not all couples are suitable for the process. Not all couples are suitable for mediation, even. Okay. I have a no litigation retainer agreement with my clients, so they know I don't do contested hearings. They know I don't do trials. So if I have a case where it's not collaborative, it's not mediation, Chinwe, you're working with the other party, I will call you up and I'll say, hey, Chinwe, you and I have a case together. How would you like to go ahead and have a meeting? I'll come over, my client and I will come over to your office and let's go ahead and save these people some money so we don't have to file motions, or take depositions or set interrogatories. And so we would meet as a four-way, and the parties meet the attorneys, realize we're not dragons, that we're not really evil, we're just human beings doing our job, but then we get onto the same page. How can we guys save you money? How can we put your kids first? How can we get you guys the information? So we commit to a full exchange of information without even using the collaborative or mediation models. So I'm trying to model a behavior, a way to practice law that opens people's eyes and experience to different ways of resolving conflict.
Thank you so very much. So final question, we're running out of time, is what is your advice for potential users and people pursuing a career in collaborative law?
Can you ask that again, Chinwe?
Your advice, what is your advice for people pursuing a career in collaborative law and potential users? So
professionals, I really encourage you to take a collaborative law training. And become, there's an introductory training.
Okay.
One of, ICP has a set of standards and ethics, which they really want you to take mediation training too. So I've taken an introductory collaborative training and many other advanced collaborative trainings, but I have taken 4 or 5 mediation trainings, which are like week-long mediation trainings, because the skills we learn as mediators are really valuable in the collaborative process, okay, as we use a facilitative approach to help the client get to a resolution, okay? So, as to, and I want you to know that my income increased 35% when I stopped litigating. Okay, when I just started doing peacemaking work, the big thing was I wasn't having to write off client bills because they weren't into me for as much money as litigation clients were. So my receivables went from like 70% to 99%. I don't really have accounts receivables because people are happy with their work. As to using, getting our clients to say, you know what, I'm interested in this collaborative process. It's important for us as practitioners to be able to talk to the potential new clients on all areas of dispute. Don't use alternative, okay? You're in conflict. There are a bunch of dispute resolution processes that are available to you to choose. I have handouts that I educate the clients with, that go from a kitchen table, just them sitting down, you know, and talking it out, do it yourself, mediation, collaboration, arbitration, litigation, you know, and it's learning as practitioners that when we're talking to potential new clients, to help them identify where it is they want to go, and then, and only then, choosing the dispute resolution process that's most likely to get them to that place. And taking that approach, the vast majority of people I talk with are choosing the collaborative process.
Oh, okay. Oh my goodness. Thank you so much for your thought-provoking insights on collaborative law. I don't even want the section to end, but I mean, we have to go because of time. All right. Thank you so very much once again. 1 minute remaining. And I would, of course, be inviting more people to speak about collaborative law, because, I mean, all the benefits associated with collaborative law is awesome. So thank you so very much, Kevin, for coming on the show. And yeah, bye-bye. Take care.
Chinwe, thank you very much. Feel free to have people contact me if they have more questions.
Okay, no worries. Thank you. Bye. Yes.